This is State of Wisconsin versus Ezra McCandless, Dunn County case number 2018 CF 125. Appearances, please.
The state appears by District Attorney Andrea Nodolf and Assistant Attorneys General Richard Dufour and Peter Hahn.
Ezra McCandless appears in person and with her attorneys Aaron Nelson and Deja Vishny.
All right. Is our counsel ready to argue the issue related to the DNA issue among many related to Kevin Scott? My understanding is that there really only were two issues related to the testimony, the DNA evidence that counsel wanted to decide ahead of time. Court has decided one already, and that is excluded at the defense request DNA evidence, finding it irrelevant, and that there's already a record on that, so I'm not going to discuss what it was. But what is that issue is what we talked about yesterday afternoon, and that being this finding with respect to some genetic material from a mons pubis swab from Ms. McCandless, as I understand it, from the sexual assault examiner kit, and that would be on a DOJ reference would be DOJ 001876, and this for in the court record, this is page 14 of 21 from document 151 filed in this matter on February 13, 2019, and it relates to the STR DNA results and conclusions related to the mons pubis swabs. Now, Mr. Nelson, I want to let you go first, as I believe it's the defense motion to, I'm sorry, it's the state's motion to exclude that evidence. Okay, so Mr. Dufour, you go first.
Yes, Your Honor. The state's belief is that it's essentially irrelevant non-evidence. It doesn't tell us anything. It just tells us that we can't exclude Alexander Woodworth and Jason Mengel. Or actually, it doesn't even tell us that. It says it's inconclusive due to the limited amount of genetic information available. It doesn't exclude them. It doesn't include them. It just doesn't say anything. It's inconclusive. And Your Honor, and I understand that the court has ruled as it relates to the other matter, but I think that was our understanding of that ruling, and our belief on that is that it essentially meant that there was nothing on this that was relevant. And I think it would be disingenuous, and I think it would be misleading to the jury to tell the jury that the possible contribution of Woodworth and Mengel is inconclusive without telling the jury that it's a mixture of a number of individuals. Because, you know, if you tell them it's inconclusive as to two people, they may wonder, well, what does that mean? And certainly the fact that it's a mixture makes that even, number one, it makes it more difficult to determine, and number two, and more importantly, it means that it could be both, could be neither, could be, you know, other individuals. And so you know, that's why we believe the fact that it's a mixture becomes relevant if this becomes admissible and if this comes in. But if it all stays out, then that makes the most sense, because it really doesn't mean anything. It doesn't say that Alexander Woodworth is even possibly the contributor to this with any degree of scientific certainty. It's not like it says, for example, with the right upper thigh swab, which is the next item on there, that profile is consistent with the profile of Alexander Woodworth, and then gives a statistical reference of 1 in 1,773 individuals. which is obviously not a very great match, but it's, about the best you can do with YSTR. But this doesn't even say that. It doesn't even say it's 1 in 2. Doesn't even say it's 1 in, it just says we don't know. And to say we don't know is somehow relevant in this case because it doesn't exclude Alexander Woodworth or Jason Mengel is stretching the possibility of relevance.
Okay, Mr. Nelson.
Don't need to quote 90402, the definition of relevant and probative value. It just needs to have the smallest, slightest possibility. And just so we're clear, I'm referring to DOJ 1832. I know Your Honor made reference to a article. I don't have that filing in front of me, but I think we're talking about the same thing. As the page you're referring to is page 8 of 11, marked DOJ 1832, Your Honor.
Well, it's page 8 of 11, report number 13.
Okay.
But the DOJ number is 001876 on the page that I have. And
I think there's duplications, but it is page, I'm referring to report number 13, page 8 of 11, about 3/4 of the way down, the bold type, mounds, pubis, swabs.
It's the same. They're just two different copies of the same record in the discovery.
So, Your Honor, as I was asking Your Honor, we're talking about the mounds, pubis, swabs, item W10A. Is that correct, Judge?
yes,
All right. What my intended cross is to deal with the term exclusionary purposes. As Your Honor knows, both the definition of relevancy under 90402 as well as the burden of proof under 140, it's the defense position that the state needs to exclude reasonable hypotheses. And so my cross-examination of Mr. Scott could go something along the lines of this. You had a swab from Ms. McCandless's mounds pubis. You tested that swab. You developed profiles from that swab. As a part of that testing, you then, the profile was suitable for exclusionary purposes only. And as a part of that, you were not able to exclude Alexander Woodworth from that profile. That's the extent of the cross-examination. I don't intend to get into consistent with, because that's not what his opinion is. I don't intend to get into possible contributions, because that's not his opinion. His opinion is the profile is, quote, suitable for exclusionary purposes only. So he tried to exclude Alexander Woodworth, and he was not able to exclude Alexander Woodworth. I think that's relevant.
well, okay, so what do you think it is relevant of? And would you please put your microphone on during arguments?
Apologize, Judge. It is relevant to the defense theory that I think we're going to tie up once it's the defense case, but as we've, I understand it's not evidence, but as I laid out in our opening, that Alexander Woodworth did things to Ezra McCandless. His hands, his body, his use of the knife were in certain places on Ms. McCandless. And the fact that we are proposing that, and the state has taken swabs of Ms. McCandless in those areas where we say he was near or on or there, they can't exclude through scientific evidence that what Ms. McCandless will be testifying to is in fact true. It's relevant to that portion of it. Their job is to rule out reasonable hypotheses. We are going to present a reasonable hypothesis. They cannot exclude that based upon this DNA evidence. That's why it's relevant.
Okay, well, again, and I'm going to look at this in the light most favorable to your client, and that is the story that, and I guess maybe that's a poor choice of words, but what you presented during your opening statement and what an offer proof has been in motions and so forth, as I understand it, and correct me if I'm wrong, but that at no time were her pants removed, that anything in that area related to cutting with a knife through the clothing, and that I haven't heard any proffer or any statement during your opening statement that there was any contact on this date by Mr. Woodworth with your client's mons pubis. I haven't heard a thing about that. Now, I add to that we don't know what type of genetic material it was, and it also indicates a mixture, and the finding is that it is suitable for exclusionary purposes only, and I read that to mean that it's not suitable to include anybody. So there's one person excluded, but again, the finding is that there's not, or due to the limited amount of genetic information available, that it is simply inconclusive as it relates to the other two individuals listed. Now, when I look at this, I just, when you talk about relevance, in the court's opinion, it doesn't make the proffered testimony. And again, Ms. McCandless has not testified. She does not have to testify. She has an absolute constitutional right to not testify, and we haven't reached that point yet. But assuming that she did, and it was consistent with what counsel has said in opening statement, in the court's opinion, this would not make that version of events or her testimony or that, however you want to characterize it, wouldn't make it any more likely or any less likely. We know that Mr. Woodworth was found in her vehicle. I mean, that evidence is in. We know that they were spending the day together. It wouldn't be a great surprise to find his DNA all over the car. I'm sure with the blood and so on and so forth, you're going to find his DNA. And so that this particular finding, in the court's opinion, if there's any relevance to it at all, the probative value is so small that it is far outweighed by the danger of misleading the jury, confusing the issues, and being misused. So the court is going to exclude, again, the report of analysis related to item W10A as previously identified here on the record. It absolutely has no relevance. But again, your objection is preserved, and for the record, Ken, I know that the defense objects to that, but that's, again, preserved for the record.
And I'm not trying to re-argue it. I just want to make clear. So both the portion, two things above that, cervical swabs, that's excluded. Mons pubis is now excluded. So there'll be no reference at all to any testing, anything at all regarding item W3A and item W10A. So there should be no questions whatsoever about those two items is how I understand Your Honor's ruling to be.
That's consistent with my recollection as it relates to item W3A as well. And is the state on the same page with that?
I guess my only thing is that Alexander Woodworth is excluded from that one, but again, I guess I'm not gonna, I think that's relevant, but to the extent that, we want to just leave it out, that's, I guess, fine.
Well, here's, I guess,
Your
the
Honor,
court's
I made a
position
ruling about that.
is that if there was testimony, I mean, there's no proffer of evidence at all that that intercourse took place, or that given the events as described, again, I don't want to call it, I just want to be careful what I call it. I mean, I don't want to characterize it in a way other than neutral, but if the proffer by the defense, and I'll just say essentially the opening statement was a proffer of evidence, there was no intercourse. There was no penetration. I hadn't heard anything along those lines. As I understand it, what was the defense expects the evidence would show is that there was this event that took place in the back seat of the car, but that no pants were undone, that there was some cutting with a knife through the clothes in the exterior from outside with clothing on, and then Ms. McCandless had the knife, and there was no sexual activity or sexual contact that is proffered to have taken place. Essentially, the defense proffer was that it was an attempted sexual assault, but that there was never any contact, any sexual contact or sexual intercourse. And so I think that the evidence related to W3A would only be relevant for the state if there was that claim that intercourse took place. So given the version, again, that you stated on the opening, Mr. Nelson, there would be no expectation to find Mr. Woodworth's DNA in Ms. McCandless's cervix.
And I'm not trying to argue, I'm just trying to clarify, Judge. I apologize if I wasn't clear about that. I just wanted to make sure that I knew what the rules were going into this, what the rulings have been. And so if that's Your Honor's ruling, item W3A, we don't talk about, item W10A, we don't talk about, the defense now would move that item W9A, which is in between those two, for those same reasons, both scientifically, based upon their opinion that it's not suitable for comparisons, as well as just the relevancy arguments, I would ask that W9A be excluded for the same reasons Your Honor's already articulated.
Well, does the state have any objection to that? W9A,
No, 9A is just basic. The only thing that concerns me, Judge, and it's not a huge concern, but it does concern me a little bit, is the jury did hear that that there was, these swabs taken by the SANE nurse as part of her exam. And I think what would probably be appropriate, there may very well be, and defense may bring in the swab, the next one, which was the upper thigh swab, which is consistent with the odds that I just gave. But I think it would be appropriate to ask ask just one simple question: were any of the swabs, did they give you anything of any evidentiary value? And the answer would be no. Just so that the jury understands it was tested and we didn't get anything.
I think I would object to that question. I don't know when Mr. Scott is going to be testifying, but I would entertain the entering of a stipulation regarding item W3A, W9A, and W10A. I don't have the wording of it right now, but I would certainly entertain something so that we could alleviate that concern. I just don't think it should be in a question-answer format.
I'm fine with a stipulation that there's nothing of evidentiary value in them. That's fine too.
I'm not agreeing to the term "nothing of evidentiary value." That is a term of art that I don't think is accurate, and we can find some other term perhaps, but
Nothing that's relevant.
again,
we're getting
Not in the
closer. All right, well, we'll talk about that. When is Mr. Scott going to testify?
He'll be the third witness we're going to have, Your Honor, today.
Okay, so that gives you a chance to think about it. But again, as I understand the events, as the evidence is unfolded, that this SANE exam was done and these samples were taken because Ms. McCandless was not able to say what had happened. That's she didn't say. The fact is, she didn't say what happened. So they did the exam in the event that, again, later she may be able to say what's happened, and so. But the fact of the matter is, when she did say what happened, it didn't include sexual contact or intercourse actually occurring. And I haven't heard anything other than that or anything inconsistent with that. So I think that should be fairly easy to come up with a stipulation in that regard. So we'll then probably take a break and finalize that before Mr. Scott testifies. Okay.
That's fine.
And with that, are you ready for your...
One other thing, Judge, we'd just be asking the court to take judicial notice that the conversion from kilograms to pounds is to multiply kilograms by 2.2 and you get pounds.
Any objection to that? That's my understanding. Just take your-
I don't know how that's relevant.
Well, but the court can take judicial notice of things that are on dispute.
It's
I'm familiar
relevant.
with that. I've done the calculation hundreds of times myself. You take 2.2 times the kilograms and you get pounds.
And it's relevant because we introduced the weight of the defendant at the hospital in kilograms. And so we want to be able to convert that to pounds so the jury understands what that meant.
All right.
That's the relevance.
Does the defense dispute that is, I mean, I think that's beyond,
Don't dispute the equation, no.
okay, all right. All right.
Okay. Yeah, that's fine.
Our position would be it's not relevant. I believe that it's in the medical records, the weight, and then,
In kilograms.
No, I think the medical records shows the weight in another form. I know Ms. Vishnu wants to talk about that. There's also another thing she wanted to correct on the record regarding some comments she made yesterday about the DNA that I want to give her that chance. I need to go to the bathroom. I don't know if we're going to get a break before the jury comes in. If we're not, I could choose this time to run out and take care of business.
All right, why don't you take care of business? Anybody else?
Yeah, let me just, Mr. Nelson doesn't need to have to be here, but the kilograms to crowns and taking judicial notice, I would argue that's not relevant because basically what Dr. Tillotson said is he doesn't know where her weight came from, and there's no testimony that she was actually weighed by anybody at the hospital. So as far as we know, that's an estimate, so there's no real reason to draw any attention to that because there's no testimony that shows that that was actually her weight at the time, even though in the chart, that was said. So that's the reason why I'm opposing having that court take judicial notice of it. Does that make sense, Judge?
Well, it makes,
I'm not sure if I'm making myself
it
clear.
makes some sense, but,
Okay, I just want to make sure that my position is clear.
okay, well, understood. But
Okay.
the court is going to take judicial notice that the formula, if you will, is, there's kilogram is 2.2 pounds.
Well, I'm not disagreeing with that fact.
And so, frankly, I understand you don't believe it's relevant. I don't know if this weight's going to come up in some other way, but I'm going to make judicial notice that is the formula.
Okay, I understand the court's ruling. I just wanted to briefly state that yesterday I said something about whether or not YSTR could be sent for probabilistic genotyping, and I have investigated that, and in fact, it cannot. So it's really got nothing to do with what's happening in front of the jury, but I just want to correct myself.
Okay,
Thanks.
very good. All right, then, Ms. McCandless, does she need to use the restroom at all?
Yeah, she says she does.
Okay,